I call Kennedy Graham.
Thank you, Mr. Chairman. Can I begin by just reiterating the assurance that I offered in the first reading and Russell Norman in the second reading of our intent to approach this very constructively with the government and with other colleagues and other parties. And we did appreciate the very constructive comments of John Carter, Minister Carter, just before dinner. He assured us that the government was genuinely trying to ensure cross-party support, and we appreciate that, and we give a reciprocal assurance that we are doing what we can to arrive at that place as well. It won't be lost on members that we do have our concerns with the bill. We do not dispute the need for legislative enactment to facilitate a fast recovery. There's common ground there. I happen to live and have a residence in Christchurch. We had mild damage, nothing compared with even the Minister and Brendan Burns and others. And I extend our personal sympathy on that basis. But we did have damage, and we do have the trauma of the experience with the earthquakes themselves and walking around town, talking to people. So I feel it in the same way. And I pledge the Green Party's commitment to facilitating a fast and effective recovery scheme. Where the point of discussion is at the moment is that the Green Party deeply believes that there should not be any derogation from the usual constitutional principles of the relationship between the executive and the legislature, and for that matter the judiciary, simply because we are moving out of emergency into a reconstruction period. And it is for that reason that we are putting forward the 6 SOPs that have been put forward in my name to try to ensure that the minimum constitutional requirements, as we understand the New Zealand Constitution to be, are not brought into jeopardy in the rebuilding of an earthquake in one city. Because it is no disrespect to Christchurch, to my fellow citizens in my own city, to say that our interest, our collective interest in which I share, in reconstruction of my city, must not come at the expense of any slightest threat to the constitutional integrity of this country. And I do not think that that is being sensational at all, because when we look at the extreme nature of the powers that may be ceded to the executive branch of our government right now tonight, then I think this is a statement that is well considered and should be taken seriously. So we rest our submission of our supplementary order papers on the basis that the powers as they are established in the current version of the draft bill are excessive to the purpose. Now, the extent to which we can narrow our differences on that basis is the extent to which we get agreement, collective agreement around the House. And we will work in the next hour or two constructively on that basis. I do not accept the argumentation that the Regulations Review Committee has in place everything that is required to assure New Zealanders that the executive, the execution of the executive powers under the bill would be sufficient or sufficiently safeguarded, because we do not think that that is the case. And to the extent it is, that is fine, but to the extent it isn't, then the current draft of the bill needs to be hauled in a bit. So, Mr. Chairman, with your permission, I would just very quickly address each of the 6 SOPs that have been put forward in my name for the Green Party. They address 6 different points. The first is judicial review. The second is the limitation of the scope of the powers. The third is the sunset clause. The fourth is accountability to Parliament. The fifth is community participation. And the sixth is what I would call municipal transparency. And the first, which is judicial review, has been touched on. We would suggest that we do in Clause 6, Paragraph 3, add at the end of that paragraph the words, unless a High Court judge determines that fundamental principles of justice will be compromised by not allowing a case to be heard. Now, I have just heard Charles Chauvel saying that he doesn't think that that is necessarily the perfect solution. Of course, we are open to suggestion of alternative wording. This is done hastily, you understand. We had considered the possibility of simply saying, without the consent of the Attorney-General. And it's a question of whether it should, Mr. Chair.
I call Kennedy Graham.
It is possible to delete it, and in fact that would have been our preferred position. But I would support a deletion. But if it is not to be deleted, then it needs to be qualified. And it needs to be qualified either by a consent of the Attorney-General or the role of the judiciary. Otherwise, the executive basically has untrammeled power under this bill. That is unacceptable. Point one. Point two, the limitation on scope. To suggest in 6.4 that you can, and we have touched on this, all of us, that there are 22 acts here. And I listened to Minister Brownlee a moment ago saying that it was considered whether you could get an exhaustive list, and then it was established that you couldn't. And it does not follow, I suggest, that we therefore open up the New Zealand statute book to potential overriding, given that there's a supremacy clause in here, that in order in council, if it is repugnant or contravening, incompatible with any other provision of a statute except for the 5 constitutional acts, that it overrides them. It's a supremacy clause. You don't go from a recognition that 22 is not exhaustive to a supremacy clause over the whole of the statute book of New Zealand. That's slightly overstretching the case, and I do suggest that I think we are honour bound here to identify the acts. If there are 22, there are 22. If there are more, they can be added in due course. This Parliament would not oppose additional acts as long as they are specific, but we should not accept a blanket executive power roaming across the statute books in the name of recovering the buildings of Christchurch. If we did, just to highlight the ridiculous breadth of the bill as it is currently drafted, we could, as it is written, it would allow ministers relevant to the Canterbury earthquake to have our head of state declare that rape, theft and bribery are no longer crimes anywhere in New Zealand.
Oh, it's ridiculous.
I know it's ridiculous. Of course it's ridiculous. And if it's ridiculous, we shouldn't allow it. So we're not disagreeing on the reality, Minister. What we're disagreeing on is the constitutional nature of our obligations. How does it? I wouldn't put it past Minister Smith to find a rationale. I mean, let's move on, because we don't want... I think the Minister has just understood the point where we're getting at. The 6 months provision, which pertains to Clause 7.3, we do suggest that there be a deletion of 1 April 2012 and a substitution of 15 March 2011 in Clause 7.3, Clause 15.1 and Clause 17b, and that there be a further clause which requires that it appears by 15 March 2011 that further reconstruction is required. The Minister, by lodging a parliamentary notice of motion, can extend the expiry provision for a further 6 months to 15 September 2011. I heard Charles Chauvel argue that there was no need to bring it forward so short. I do suggest that 18 months is too long for a blanket power like that. A lot happens in 18 months, and I just respectfully suggest to the Minister that the government consider making the period shorter and renewable, and the Parliament can revisit the renewable issue of the bill with good intent after 6 months or whatever further period is required. It should be less than 18 months. The other supplementary order papers pertaining, I understand that there has been some support expressed for the insertion of the Local Government Official Information and Meeting Act 1987, and we appreciate that. We do still adhere to the suggestion that there should be more individuals from Christchurch and the Christchurch City Council nominated to